a complicated Supreme Court decision on prayer in public venues.
There is some language in the decision that's very affirming of the need of states to respect religious diversity, to allow religious expression in the public square. And yet, on the other hand, governments are actually defining morality, imposing morality. So the question is, what is the source or basis of that morality?
On the feature interview today, the president of the Evangelical Fellowship of Canada on last week's Supreme Court Saguenay decision. ARPA lawyer Andre Schutten also weighs in on the decision on the news portion of the program. And on the news, homeschoolers in Alberta are up in arms about some new provisions in the new provincial budget there. Also, some shocking new statistics about live birth abortions in Canada.
And now, Lighthouse News. Lighthouse News is a presentation of ARPA, the Association for Reform Political Action. Here's your host, Al Sebring.
The Supreme Court of Canada issued another landmark ruling on religious freedoms last week. The decision centered on a practice in Saguenay, Quebec, where the mayor would open municipal council meetings with an expressly Catholic prayer. A local atheist originally took the case to the Quebec Human Rights Tribunal.
The tribunal ruled that, in fact, this prayer by the mayor, as mayor, like in his official capacity, was in fact discriminatory, ordered the mayor to stop doing that, and also ordered damages in the amount of $30,000 in favor of this atheist. The city vowed to fight this decision. They appealed up to the Quebec Court of Appeal. Quebec Court of Appeal said that what the mayor was doing was reasonable. It wasn't overtly Christian. It was more traditional than anything. And they reversed the decision of the tribunal. And then it got appealed to the Supreme Court. And they ruled basically unanimously that, in fact, what the mayor was doing was discrimination because the state, they said, has to remain neutral on all things religious.
ARPA lawyer Andre Schutten says the decision is complicated, but it does not appear to ban all religious expression from government-sponsored events such as municipal council meetings.
They really focused on the fact that in this case, it was the mayor in his official capacity as mayor saying this prayer, and they said that that action then created a preference for one religion over all others, and they saw that privileging one religion over others is not good. I suspect that if council allowed an Aboriginal smudging ceremony or something similar to happen before council, one day they'd let that happen, and then another day an imam came in and did a Muslim prayer, and a third day a Christian pastor came in and did a Christian pastor prayer. I suspect that would still be okay, but it's the fact that the mayor himself in his official capacity as mayor was doing this prayer and did it every day, always. They seem to have a problem with that.
We'll have much more on this ruling coming up on the feature interview with EFC President Bruce Clemenger. In other news, the Prentice government in Alberta brought down a budget earlier this month, just before going into election mode. There's considerable concern in the homeschool community about what are essentially cuts to funding for homeschoolers in that province. Paul Vandenbosch heads up the Alberta Home Educators Association.
The budget actually, in terms of home education funding, gives an increase to the public schools. If you register with a public school board to home educate under their authority, you will actually get a little more money this fall. But if you are with a small private school, and more than 3/4 of home educators in Alberta are with small private schools, you actually are going to get less. And this is a change because it creates a two-tiered education system. And we object to that on principle. But in addition to that, what the budget does is it gives an enrollment cap. The enrollment cap means, in effect, a funding freeze. If you are home educating this school year, 2014-15, then you'll be fully funded. If you are beginning homeschooling in the fall, you get nothing. There's no money for you. Sorry. And so some of those families may end up paying out of pocket.
Vandenbosch says there's a certain irony in these budget cuts because the stats show that homeschooling actually saves taxpayer dollars.
Home education costs Alberta taxpayers, in round figures, $1,600 per school year. And half of that goes to the family for resources, etc. The bill for a student attending a public school in Alberta is over $10,000. So every student that homeschools saves the taxpayer $8,400. And this year, there are almost 10,000 home educating students. Simple math, over $80 million a year. And yet, it's the home educators that are getting squeezed the worst.
There's another factor here, too. The notion that homeschool numbers have been consistently rising in Alberta. Vandenbosch says he has every indication that those numbers will continue to go up.
I've received phone calls, dozens of them, from families who are saying, My child is in public school. I'm worried about Bill 10 and other bills like this. Can I start homeschooling? And the answer, of course, is yes. You have the right to homeschool. Just please understand, we don't know what the financial implication is going to be. So I fully expect this fall may be one of the largest increases in home education ever. Vanden Bosch says homeschoolers definitely intend to make this an issue in the ongoing Alberta provincial election campaign. One thing more in the news, some shocking statistics on abortion. Last year, we featured pro-life blogger Patricia Maloney on this program. She's been trying to force the Ontario government to release the actual statistics on the number of abortions done in that province. She hasn't been successful on that front. The battle's ongoing, but she did manage to unearth some other numbers from Statistics Canada last week. These numbers, covering fiscal year 2013 to 14, show that 182 babies were left to die in hospital and clinic operating rooms after surviving failed abortions. Maloney uncovered similar stats a few years ago, showing a shocking 491 of these cases between the years 2000 and 2009. Mike Schutten from We Need a Law says these numbers point up the inconsistency in Canadian law on the abortion issue.
We're seeing this tacit acceptance of infanticide because Section 223 of the Criminal Code, subsection 1, states that a child only becomes a human being when he or she has completely proceeded in a living state from the body of its mother. Section 223 also has a subsection 2, which states, and I quote, "A person commits homicide when he causes injury to a child before or during its birth as a result of which the child dies after becoming a human being." So these are babies that have become, under the law, as ridiculous as the law is, they have become a human being. And there is no justice for these babies.
Schutten says even with that second subsection of the Criminal Code, there's an obvious reluctance on the part of the authorities to deal with this issue.
When Patricia Maloney broke the story a few years ago about the 491 babies, there were 3 MPs who wrote an open letter to RCMP Commissioner Bob Paulson asking for an investigation into this, and to date they have heard nothing. So we're in that situation where, because we're one of only 3 countries in the world with no protection whatsoever right up to the moment of birth, nobody wants to deal with this topic. So again, we're calling on our elected lawmakers to tackle this issue and to provide recognition and protection of the rights of children before birth at some point, so that we're not left with these legal conundrums.
When we come back, an in-depth look at the Saguenay Decision. Just how much or how little religious expression is actually allowed in Canada's public square.
Introducing Legal Maxims, a new feature on the ARPA website. A legal maxim is an established principle or proposition of law that is universally admitted as being just and constant. Although the majority of Latin maxims were developed in the medieval era, they still possessed interest and value. Read a maxim, learn where its foundation lies in Scripture, and how it applies to issues we face today. You may even learn some Latin along the way. That's at arpacanada.ca under Legal Action.
And we're back on the program. As you heard in the news portion, the Supreme Court of Canada issued yet another landmark ruling on religious freedoms last week, the Saguenay Decision. It follows on the heels of the Loyola case, and this one wasn't as positive when it comes to the issue of freedom of religion. The court essentially said that so-called religious neutrality has to be the ultimate standard for public bodies and institutions in Canada. In this specific case, that meant there could be no town-sponsored Christian prayers to open municipal council meetings in Saguenay, Quebec. The Evangelical Fellowship of Canada was an intervener in the case, and today I'm talking with Bruce Clemenger. He's the president of EFC. First of all, Bruce, welcome to the program.
Well, thank you.
In essence, did I get that right? Is that pretty much what the court said, that public institutions have to stay religiously neutral?
That's the principle that they're advancing, the idea of state neutrality. But again, how that is understood and how it's applied is a bit confusing in the decision. So there's going to be much conversation that unfolds trying to interpret what they meant by this. Basically what it was is Saguenay, a municipality in Quebec, was in the practice of opening their city council meetings with a prayer. Before the prayer, the mayor and most of the city councilors crossed themselves and said in the name of the Father, Son, and Holy Spirit. They prayed the prayer, and then at the end of the prayer, they crossed themselves again. There was a fellow named Mr. Simoneau, who was an atheist, who objected to this. He thought it was a distinctively Christian prayer and filed a human rights complaint in the Quebec system. And the tribunal found that, yes, the prayer was decidedly Catholic, and it was discriminatory to him in terms of his atheistic beliefs. That went to the Court of Appeal in Quebec. Court of Appeal actually overturned the tribunal decision, and though they thought it was something that should be permissible in terms of the prayer, and went to the Supreme Court, and they overturned that Court of Appeal decision. The decision actually does not ban prayer at government functions. It doesn't say that it's unconstitutional or contrary to the Charter. Again, this case was not a charter case. It was really a case at common law about what the state neutrality means. But really what they said is that it wasn't necessarily the prayer, but it was the context and circumstances of the prayer which led the Supreme Court to feel that it was inappropriate. It was the crossing and reciting in the name of the Father, Son, and Holy Spirit, and also the mayor in public comments about the prayer framed the prayer as something that he was doing as an expression of the Lordship of Jesus Christ.
But this concept of religious neutrality, I've heard some people say that this ruling kind of eviscerates the supremacy of God provision that's foundational to the Charter. What's your take on that argument? Does it depend on one's interpretation of who God is? Is only the historical Christian God being banned, or is there more going on here?
I think it's more broad in what it addresses. The court actually noted two other examples of prayers being offered. One was in a small town in Ontario, Renfrew, which a number of years ago had their prayer challenged. And the court upheld the prayer. It was a non-denominational prayer, and the court thought that if it did infringe on anyone's religious expression, it was a minimal impairment. And the Supreme Court also noted that the House of Commons begins every day with prayer. And in both cases, the court distinguished those examples of Renfrew and the House of Commons from the situations in Saguenay, saying that the context and circumstances are different. And they felt that the Saguenay prayer crossed a line because not the prayer itself, but because of the demonstrations before and after and the stated purpose of the prayer. And so they didn't ban all prayer. They said that it was a decidedly sectarian prayer, or a prayer that promotes one religious belief over the other. So we'll see how that unfolds. I know a lot of city councils across Canada are now looking at the decision. They're trying to decide whether their practices would cross the threshold. The problem with the decision is that it gave no test. It said what it found unacceptable. It showed two examples of practices that might be acceptable, but it didn't actually lay out a test of what would be acceptable, what's not. And again, they kept referring to this notion of state neutrality. By state neutrality, they don't think that a state can be absolutely neutral. They talk at points of the decision and saying that often a state or a government may celebrate the religious traditions of the government or of the jurisdiction. They didn't have a problem with that. The question is whether the religious expression that's being allowed is actually serving a religious purpose.
This opens up another can of worms, but what about the religious rights of people who work in government, whether they be politicians or public employees? The way I understand this ruling, it kind of prohibits them from most kinds of religious expressions when they're wearing their public servant hats. It's okay to pray in your prayer closet at home or in your church, but it's not okay to talk about your faith in public.
Yeah, what the court did is it did talk about the duty of religious neutrality of state officials. So these are, government employees, public employees who are in the performance of their functions. They're not to profess, adopt, or favor one belief to the exclusion of all others. So at one level, we understand what they're saying. You need to be fair and respectful of religious diversity. You're not supposed to discriminate against people on the basis of their faith in terms of the services delivered. But this language would also suggest that, perhaps wearing a cross or wearing a turban or a yarmulke, is that professing belief, is that captured by this? And that's where the ambiguity is. It has this language. They say that the state official should not engage in this activity, but they actually don't explain what they mean by that. In the context of the prayer, they're saying that it's inappropriate for a state official during a government function to offer a sectarian prayer. But the language of the decision implies much more than that, and that's what's not clear. And that's the frustrating part of the decision, is that they come out with these statements in here, these arguments that are made, but there's no clarity about what their reach will be.
You see any other potential spin-offs on this long-term? If religious expression is banned from public discourse and the government's not allowed to promote one worldview over another, I'm thinking, for example, of Bill 10 in Alberta. Some people say it imposes secular humanism onto the human sexuality paradigm with this gay-straight alliance thing for Christian and independent schools. Might the logic in this decision work against laws like Bill 10?
Actually, you can read it both ways. I mean, the irony of the decision is that there is some language in the decision that's very affirming of the need of states to respect religious diversity, to allow religious expression in the public square. So that's encouraging. And yet, on the other hand, that's what governments do through instruments like the Criminal Code. They are actually defining morality and imposing morality. So the question is, what is the source or basis of that morality? And might this decision actually be used to challenge governments when they're seeking to impose a morality that may not be specifically rooted in any one religion, but more of a secular-based morality? Because in the decision, they did make it very clear that the atheist was covered by freedom of religion and freedom of conscience protections in the Quebec Charter. And they said that the freedom of religion extends to people of no particular belief or atheists and agnostics. So they consider atheism and agnosticism as a religion for the purposes of discrimination. If that's true, then any type of secularist moral agenda that the government may be trying to impose is, in effect, kind of a religious morality. And this case would say you cannot impose that. But given the way that the decision is written, it's not clear how this will unfold.
It's going to be complicated. We'll keep watching it. Bruce, thank you very much.
You're welcome.
This has been Lighthouse News, delivering news and commentaries on today's current events to equip Christians for their task in the public square. Production Manager Brian Grimm, Technical Director Nate Bosher. Questions or feedback? You can leave us an audio comment by clicking on the answering machine button at the top of the Lighthouse News homepage. Or you can send us an email, info@arpaccanada.ca. Be sure to join us again next week for another edition of Lighthouse News.